Aloha. Hello. And so this is February 13th, 2025. And this is the regular meeting of the Hawaii Civil Rights Commission. And at this time, the meeting will come to order. Thank you. So, uh, oh, very good. Orasima's here. Okay, so we should at least, I'm told, according to the
Hmm.
sunshine law, introduce everybody who's here first so that we know who's here. So we have uh, Marcus Kawatachi, who is the executive director, and we have Heather McVeigh, who is it assistant executive director or deputy executive director? And then we have Sandy Yoshimura. And so, Sandy, what is your title again? I'm sorry. It's
Administrative assistant
okay. It's not.
for the chief counsel.
Oh, okay. Adjudication administrative assistant.
Yes.
Right.
Right.
Okay. And we have the commissioners. I am Dr. William Puett. I'm the chair of the Hawaii Civil Rights Commission. We also have um, John Matsuoka, who is commissioner, and Arasima Mueller, who is a commissioner, and Joanne Adams, who is a commissioner. And it looks like we have, oh yeah, I'm sorry, Miss Joey Badua, who is, what is your, I'm sorry, titles?
Enforcement attorney,
Enforcement attorney, thank you very
Dr.
much.
Pillay. Thank you.
Thank you. Okay, and see, we have a guest, Michael Galoyu Jr. And if I missed anybody, let me know, but I think that's everybody. So moving along to our agenda, the first item of business is approval of the two sets of minutes for November 7th, 2024 and November 19th, 2024. These were posted, of course, on the Civil Rights Commission website. So at this time, I'm going to deal, you always, according to Roberts, deal with the oldest first. So November 7th, 2024 minutes. Uh, If you have them with you, I sent them around to all the commissioners. Are there any corrections to the November 7th, 2024 minutes? Hearing none, the uh, November 7th, 2024 minutes are approved as circulated. And now November 19th, 2024 minutes. Are there any corrections to the November 19th minutes? Okay, so hearing no corrections, the minutes of the November 19th, 2024 Civil Rights Commission meeting are approved as circulated. And that brings us to the executive director's report. So the chair recognizes our executive director, Marcus Kawatachi.
Thank you, Chair. I may need a point of clarification as far as how we shall proceed here. What we presented last time on January 28th is exactly what I would present this time. So is there a way we can simply approve having reviewed the materials prior?
Yeah, so these are reports, and reports don't get adopted or
Okay.
voted on. All right. So the only stickler, and I'm not the attorney in the crew, but the question is for any of these things, the previous meeting was decided to be null and void because of a notice issue. So that means that any regular business that we're going to be doing has to be redone, as we just did with the approval of minutes.
Oh,
So um, I think because this is a report, uh, I don't have a problem unless you want to just quickly touch on anything you consider important for the new for Michael Galoyu, because he's the only person who wasn't here.
uh, no, I will simply say that both of these reports presented the data as of the date of our last meeting with regard to both our mediation program and our overall caseload. And so as reported in every meeting, it's just a snapshot of the data at that point in time.
Okay, and is there, we'll be putting some of this stuff in the minutes, I suppose. of this.
Yes.
All right.
They will be in the minutes.
Okay.
And apologies for the mix up with regard to the posting. That will not happen again. Thank you.
Thank you, sir.
Okay.
Okay, well, if that's sufficient, let's move to the.
I
chief-
have a question.
Oh, yes, please,
Just
go ahead.
for the record, it did mention in those November minutes that in about this time frame we'd be hearing from Judge Hayashi. Have we heard from her?
Is that in the next part, the chief counsel report?
Oh, I
It
beg
is in
your
the
pardon.
report, correct? Yes.
I beg your pardon. Sorry.
No. Very good question.
I
And
I was
yes.
just eager, I guess. Thank you.
So I can, in the chief counsel's absence, I can report on that particular item, which is that Judge Hayashi did issue her proposed findings of fact and conclusions of law. And as mentioned in the previous meeting, that will be transmitted to an assigned attorney general to look over and provide advice to the commissioners. And so that is going to be happening. I think in terms of the order of things, there's no particular rush for those proposed findings to be reviewed, but we will get to them, I think very soon, but we want to focus on the legislation today during this meeting. Okay. And moving on, the only update on the proposed amendments to the Hawaii administration did get approval of the director of the Department of Labor and Industrial Relations to forward those proposed rule amendments to the governor. So barring any mishap, I think we are on our way to having those rules officially amended, and we will be reporting to you as that becomes final.
Okay. Unless there are any questions about item 4 there on our agenda, the chief counsel's report, let's move on. So as you can see, the next part of our agenda deals with discussion on legislation. And we have to basically go through the entire set again because the last meeting's votes, are invalidated. Let's get into that. And I'm going to ask, Marcus, are you going to lead us through the, oh yeah, we first have
Yes.
a motion. I'm sorry. Before we get into all the different legislative reports, and you see this hopefully on the agenda, we have to adopt a motion to grant authority for HCRC staff to give testimony consistent with positions already approved by the commission vote on bills that are identical or substantially similar to previously introduced bills. So this is something that the commission and the commissioners do each year because things pop up, and this gives the staff and the director the ability to submit testimony, which is essentially, the same as the testimony we gave on similarly written bills that were submitted. So I'd like to ask, okay, is there any objection to granting authority for HCRC staff to, well, I should say, is there any debate about the motion to grant authority for HCRC staff to give testimony consistent with positions already approved by commission vote on bills that are identical or substantially similar to previously introduced bills? So if you have any debate about this, or if you want to say something about it, now is the time. And this invitation is also open to our guests. So I don't hear anybody who wants to speak to this.
Yeah, this is Arsima. I think it makes sense. I mean, we can't have meetings. There's bills that come in all the time. We can't constantly have meetings to address them as they come in. So it makes sense to me.
Great. Okay. Anybody else wants to say something before I ask if there's any objection to its adoption? Last chance. Again, not hearing anything. This time, I would ask, is there any objection to the adoption of this motion? I don't want to have to read again, but there it is. So hearing no objection, that motion is adopted. Now I'm going to ask that the executive director sort of walk us through the bills that some of these are familiar because we tried to do this earlier, but we have to do it
Yes.
again. So
Right.
please come in.
I will do so. Well, let's looking at the agenda, the way, and this is the most current amended agenda. The way that the bills are listed, are initially those which were discussed during our last meeting. So we'll go through each of them, but because I believe we had discussion and they may be familiar, it may be a fairly short process for each. So we went from SB 7 all the way through SB 170. Those were discussed last time. And then once we finish with 170, I'll be introducing the bills we have not discussed and but separated into categories, which I'll get into once we get to that point. So SB 7, starting off, is relating to bullying in the workplace. If you recall, this was a bill having to do with requiring employers to take measures to prevent employees from abusive conduct that would not fall within our jurisdiction as being harassment because of protected basis, but on non-protected bases. And so the commission action ultimately was to take no position.
So is there anybody who wishes to speak to this at this time?
I see Commissioner Adams has her hand up.
Okay, please.
Yeah, sorry,
Joanne,
you're
you have
muted.
to unmute.
Sorry. I just wanted to state briefly that I felt that we should take the position that we support any efforts to minimize or eliminate bullying from the workplace, particularly since we do later take positions on other bills that are even further removed from our scope of authority than this one.
Thank you. Anybody else wishes to speak to this? John or Arcima? I'm trying to remember the debate myself.
Hey, yeah, I think it's kind of a gray one, but I remember that there was some type of logic around not supporting the Lunar New Year's because we're not supporting the bullying bill. And I don't necessarily see the comparison. I think they're both relatively gray, but one has to do with bullying, one has to do with recognizing a cultural event in Hawaii. So I just wanted to make that statement.
Okay. So, Arcima, did you have something?
No, I agree with the the position as stated. So I don't have anything else to add today.
And as stated, is that we do not endorse or we take no.
Not taking a position. Right? I believe
Yes.
that's what Marcus said.
Yeah,
Okay.
that was ultimately the action
Yeah.
taken.
Yeah,
yeah.
I don't have anything further to add today. Thank you.
Okay. So, if we do not have a motion to endorse, then we take no position, basically. So, last time there was no motion adopted to endorse, which is why the end result is that we take no position. All right. Joanne, do you want to make a motion to endorse?
No.
Okay.
I just wanted my comments on the record.
Sure. Okay. So I'm I'm going to defer to the discussion that we had last time, but I do remember there was an issue of it was trying to put something under our authority that's, you know, or meant to, it's not really under our authority. So Marcus, unless you can correct me on that, I think that was the reason that we decided to take no position.
That's my recollection as well. Yes.
Okay, and there being no motion to endorse, then we will continue with that
Okay, thank
comment
you.
or whatever, take no position. Next one.
All right, SB 31. This is regarding discriminatory restrictive covenants in the transmittal of property. And so it would allow an easier way than is present now for parties who are transmitting property from one person to another to agree not to enforce the discriminatory covenants. And the action taken by the commissioners was to support.
Okay. So we'll take up the motion then to support Senate Bill, do I have this right? 31, correct? Is that 31?
31, correct.
Okay, Senate Bill 31. And so is there any objection to the motion to support Senate Bill 31? Okay, in which case the motion is adopted to support Senate Bill 31.
Okay. Next, we have SB 44. This bill would authorize the counties to prohibit discrimination against a renter based on the renter's source of income. I recall we had public input last time, and the action of the commission was to strongly support.
Okay, so the motion is to strongly support, we'll stay with that, Senate Bill 44. Is there any discussion? Hearing no discussion, is there any objection to adopting the motion of the Civil Rights Commission or the Civil Rights Commission to strongly endorse Senate Bill 44? And hearing no objection, the motion is adopted that the Civil Rights Commission will strongly endorses Senate Bill 44. Okay.
Okay, moving on to Senate Bill 47. This was the Lunar New Year bill.
Mm.
There was some discussion, and ultimately the commission took the position of taking no position.
Okay, so taking no position is accomplished by not not supporting or opposing, and so unless there's a motion from the commissioners, otherwise the Civil Rights Commission will take no position. Is there a motion or any debate?
What was on that particular bill, was that consistent with the staff recommendation? Taking no position? I don't recall.
Well, the staff position was to support, and the rationale was simply to recognize the diversity of cultures within the state. And it was not a strong support. It was, sort of, we recognize everyone. So, we support that. Yeah.
Well, then, anyone else want to debate this or to make a motion to support this? If there is no motion to support this, then we're going to leave it alone.
I kind of think it falls under the Civil Rights Commission purview that, supporting cultural diversity. So, yeah, I mean, maybe we could talk about it a little bit more, and just kind of following the sentiments of the staff that it is, celebration of diversity in Hawaii. So,
Are you moving to, so we can have discussion a little bit more or not? John, are you moving to support this bill?
yeah, I would move to support the bill.
Okay, let's move to support the bill. We don't need a second because our group is under the limit for this. So is there any discussion on this motion to support Senate Bill 47, which is the Lunar New Year one? Joanne?
I appreciate John's position of cultural diversity. And it certainly, frankly, sticks in my craw that Good Friday is a state holiday. So I do like the idea of supporting the diversity of culture. My concern was whether holidays is part of our purview. So if people who've been on, anybody on the commission who's been obviously on longer than I have, have we in the past supported state holidays?
I recall we did support adding Martin Luther King Jr. Day, for example.
Okay.
And I think that's one thing that we can probably agree would fall within our expertise. And I'm trying to remember others, but I mean, there are every year bills that come up for new holidays, and I think generally we try not to pick one over the other, as long as it's relating to something that is important to the residents of this state. So anyway, I mean, I don't, again, as staff, we don't really have a strong opinion on this matter, just that if we had to take a position, it would be to support.
Okay, is there any further debate before we ask the question?
I mean, I don't really have a strong feeling one way or the other, but I do recall, Joanne pointed out if we weren't gonna support the bullying in workplace, it didn't quite make sense to support holidays. And so that's why I voted, or I didn't want to take a position, because I kind of agree with that. But I don't really have a strong feeling one way or the other.
Okay, so the commissioners have all had an opportunity to speak on this. So are there any objections, or is there any objection to the motion to endorse? And so you would,
I would object on the grounds of the holiday part.
okay. And Arasima, would you object?
Yeah, I'll agree with John.
Okay, so on the other hand, John, you would support this, so that's two of our members opposed and one in support. So I am, as chair, not going to vote because it wouldn't make a difference. It would be a tie vote, and a tie vote fails. So as a result, the commission will take no position on the House Senate Bill 47 relating to state holidays for the Lunar New Year.
I think there's another bill that has something to do with Hawaiian culture that we're going to be looking at. And so, it kind of gets complicated. I mean, is that something that we're not going to take a position on either? Because we don't support holidays. And then we get into this whole thing of, well, we support a Hawaiian holiday and not a Chinese holiday. And anyway, I mean, I don't have strong feelings about it either. And I hear Joanne's point about Good Friday. But yeah, it's just, we just get into this kind of complicated field of like, well, do we have preference for one group or over another, or a certain type of holiday or religion or and so on.
Yeah, that's actually, I think that for me is why I would not want to be in a position to pick one over the other. Right?
Mm.
So I don't think that that's within our purview to make what say, well, this is a good holiday and that's not a good holiday. So that's actually part of the reason I wouldn't support this holiday, because I don't think it's my place.
Okay, well, let's move along. We had a vote. By the way, when we don't have unanimous consent, then the individual votes of the commissioners has to go in the minutes. Okay, so that's how the minutes will reflect this. And therefore, moving right along, so we're not going to take a position on Senate Bill 47. How about Senate Bill 55?
55, this bill would require all state agencies to make their rules accessible, digitally accessible and searchable. And we just think that this is something we would support in the effort to increase accessibility, particularly with those persons with disabilities.
All right, so the motion is, we can assume, because it's coming from a staff recommendation, to support Senate Bill 55. Is there any debate? Hearing no debate, is there any objection to the Civil Rights Commission endorsing Senate Bill 55? No objection, therefore, we'll adopt that recommendation to support Senate Bill 55 relating to administrative rules being made digitally accessible. Next.
Thank you. So next is Senate Bill 59 relating to algorithmic discrimination. So we had some discussion about this bill, which would prohibit algorithmic decision-making in a discriminatory manner, and other requirements of reporting and making annual reports to the Attorney General's office. We would, our staff recommendation, or actually the commission action, was to strongly support, and the staff would agree with that. Again, in the effort to just reduce any sort of discrimination, and when we know that the algorithmic decision making has become a source of controversy in the way that it's being applied in potentially discriminatory manner.
Okay, so with staff support and previous consideration, I think we took this up in previous years. The motion is to endorse. Do we say strongly endorse or just endorse? Whatever.
It was strongly support.
Strongly support Senate Bill 59, which is regulating and relating to algorithmic discrimination. Is there any debate? Okay, hearing no debate, is there any objection to the motion to strongly support Senate Bill 59 relating to algorithmic discrimination? And hearing no objection, the motion is adopted for the Civil Rights Commission to strongly support Senate Bill 59. Thank you. Moving along.
Very good. Senate Bill 116. This would establish penalties for discriminatory reporting to a law enforcement officer, and on the basis of various protected bases. This bill would require the Department of Law Enforcement, in consultation with the Hawaii Civil Rights Commission, to provide guidance to the public on the enactment of this act. We support, we recommend support as staff, and that was adopted by the commissioners last time.
All right, so the motion is to strongly support Senate Bill 116 relating to discriminatory reporting. Is there any discussion?
Just correction, it was a support,
Uh,
not strongly, just support.
Oh, just support. Okay, thank you. So then the motion is to support Senate Bill 116 relating to discriminatory reporting. Any discussion? Okay, hearing no discussion, is there any objection to the motion for the Hawaii Civil Rights Commission to support Senate Bill 116 relating to discriminatory reporting? And hearing no objection, the motion is adopted for the Hawaii Civil Rights Commission to support Senate Bill 116.
Senate Bill 117 relating to defamation, sexual misconduct. So this was discussed, and it would protect individuals who make claims of sexual misconduct from defamation lawsuits. And the standard would be unless the claims were proven to be made with malice. And so there was discussion amongst the commissioners. Ultimately, the action taken was to take no position.
Okay, so we have no motion to consider. Is there anyone who wishes to make a motion regarding Senate Bill 117 relating to defamation and sexual misconduct? I think the rationale, if I can remember, is that you don't want somebody to fear being sued for defamation because they make a sexual harassment claim. So, which is what would end up if the bill is adopted, from what I understand. I'm going on memory. So, if that's not correct, I would ask staff to correct me.
Yeah, I think actually the intent of the bill is what you're saying, Chair, is to not have persons coming forward with sexual harassment or sexual assault claims to fear defamation suits. The discussion that took place amongst commissioners was that there's already standards in place with regard to defamation, and to lower that standard to, made with malice was not something that the commissioners supported. So ultimately, I think commissioners were not in support of this measure.
So unless there is a commissioner who wishes to make a motion, we will, the default on this will not take a position. No position. And listening for someone to jump up has not happened. Therefore, without needing a motion, that's the end result. We will not take a position on Senate Bill 117.
Okay. Okay. Senate Bill 149. This is relating to accessibility and public accommodations, and it would be the bill would create an unlawful discriminatory practice in places of public accommodation to deny a person with a disability full and equal enjoyment. And this is with regard to digital services. And I'm paraphrasing a little bit, but it expands basically what is considered a place of public accommodation to include the digital realm. And so staff was in support, and the action of the commission was ultimately to support.
Okay, so with that as the staff recommendation, and from our previous discussions, the motion is to for the Hawaii Civil Rights Commission to support. Did we say strongly this time? The Senate Bill 149 relating to accessibility in public accommodations. And is there any debate? Hearing no debate, is there any objection to the motion to support, I'll just say support this time, uh, Senate Bill 149 relating to accessibility in, in public accommodations? Hearing no objection, the motion is adopted for the Hawaii Civil Rights Commission to support Senate Bill 149 relating to accessibility in public accommodations. Okay, we're getting to the last one of that set that we did.
That's the last one we discussed last time, which was Senate Bill 170. And it was proposed to amend the state constitution to establish the right of each person to own the data they generate on the internet. We felt that it was not within our purview to weigh in, and ultimately the commission action was to take no position.
All right. So since there was no motion proposed by the staff or the commissioners last time, is there any member of the commission who would wish to move to support or oppose? Since I don't see any commissioner rising to that, then no debate is necessary. So as a result, we will not support Senate Bill 170 relating to individual data protection, internet privacy.
Okay. Thank you. So now we move on to the rest of the bills, and we're going to deviate a bit from what's on the agenda because since the last time we met, the legislature has had various hearings. Bills have progressed or not progressed, and so we can report on the status of the bills that were listed on the agenda. So, well, first of all, there are some bills that are simply dead at this point. And so in the interest of time, we're just gonna not discuss them. I mean, there's no need to. So we'll just bypass those bills that are dead. I'm going to start sharing. And okay. Oops, did that work?
Is the 2025 legislative summary that was the board packet? Yes, no. Ooh, no, that's okay. Go ahead.
Yeah, no, I'm gonna this is something you have not seen, so it's just
Oh,
for discussion purposes, it'll help, I think. So we have a bunch of bills for which the staff recommendations to take no position. I know last time we just went through, item by item, but in the interest of time, and I think there was maybe some discussion about the way we should present them. So these are bills that we think we've been monitoring, we've been reviewing them, we've had discussions, and the staff ultimately has found that our position would be to take no position on these bills here. So I'm just going to scroll down just quickly to see. Okay, so there's however many that is. And I'll go through them one by one. And I don't know if the commissioners would like to have discussion at all or
So
yes,
let's,
go ahead.
since the staff is not recommending we take a position on any of these, if you just read through the set and then I'll
Mhm.
open it to the commissioners to see if there's any one of these that they would like to take a position on. All right, but
Understood. Okay, that makes sense. So I will just read what's posted here. First one is SB 199 relating to Hawaiian culture. It would require the Office of Hawaiian Affairs to establish and maintain Native Hawaiian cultural centers within the state. It would require the office to submit reports to the legislature regarding the office's compliance with this act, and it appropriates monies for the planning and design of the first Native Hawaiian Cultural Center. Okay, so that's the first. Second would be SB 396 relating to commuting. It would require the Director of Human Resources Development. I'm gonna actually tell you what this is about because this doesn't tell you anything. Basically, it's that state employees get a substantial discount on parking. And so what this bill would do is for those who do not drive and need parking would have some sort of appropriate discount or benefit if they, ride their bike, if they, ride the bus. So that's what this bill is concerning, is to sort of equalize the benefit, depending, no matter what the person's mode of transportation is. Okay. SB 416 is a bill that would prohibit rental agreements from prohibiting tenants from keeping pet animals in dwelling units, subject to certain conditions. So in other words, it would allow pets in most circumstances, is what this bill would allow in rentals. HB 103, this is regarding criminal sentencing. So it changes the age for which individuals are eligible for life without parole sentences from 18 years or older to 21 years or older. Okay. HB 304 relates to the Hawaiian language. And so this concerns documents that if they were in Hawaiian, drafted in Hawaiian originally, and then translated into English, and then there's some dispute about, what the document means, that the original Hawaiian language version would be held to be correct. That's what this bill references. HB 466, this is relating to evictions. It prohibits landlords from terminating certain tenancies without cause, establishes criteria under which landlords can undertake a no-fault eviction, and then even when proceeding with a no-fault eviction, to offer relocation assistance to the tenant or a waiver of the final month's rent. Okay, so that's a number of things relating to evictions. HB 671 is relating to Native Hawaiians. This one we were a bit puzzled on, but it requires DBED to identify legislative districts in the state in which the majority of the population consists of Native Hawaiians. Next, we have HB 755. This is relating to paid family leave. And this is one where we were aware that there's testimony from DLIR, of which we are, a member, in opposition. And so this is relating to establishing family medical leave insurance and paid family leave. So there's creating a system for paid family leave, and it would be within the DLIR. And then lastly, we have HB 1496. So this is relating to, I believe, the Hawaiian language immersion schools. It's Ka Papahana Kaiapuni program. So it establishes a complex area superintendent for that program, and then have some requirements about the makeup of their board. Yeah, so that would be the last one. Okay.
Thank you. So the question is, are there any of the bills on this list that a commissioner would like to move be supported by the Hawaii Civil Rights Commission?
I'm curious about the purpose of the Hawaiian district. Is there any more information about that? Why they would do that? I mean, I live in a Hawaiian district, and I'm just wondering what's the rationale for that?
We were not aware. I can pull up the measure and see if there's anything that we can glean from what it states. So that would be
Further down,
where is
right?
it? HB 671. Okay. HB.
I can jump in and add that I did
Sure.
actually monitor one hearing on this measure because I was curious, and I believe at the time the only testifier was DBET, and their comments noted that, well, this is an HD1, so their comments noted that as it was drafted originally, there was actually the legislative district that would have qualified under the amount that they had chosen, and I forgot how much that was. So the committee did adopt their recommendation to change the amount to 25%, but it didn't, I'm still not clear on what the purpose of this designation would be. And there were, at the time that I saw it, there may have been more testimony since then. There wasn't any other input from any other agency or individuals, so it's a mystery.
Seems to be saying that they shall be designated, if they meet that threshold, a native Hawaiian notable, is that right? Yes, notable district for purposes of representation and recognition.
Hmm.
But I can see recognition, but I'm not sure what they mean by representation. So anyway,
They're referring to districts. Are they referring to voting districts, or where do you draw the line on?
legislative districts, yeah, it would be like House District this or Senate District that, right? Any further discussion?
The other bill having to do with Hawaiian immersion, Kulakaeopuni. I'm not quite sure what that means either, but I to me it sounds like kind of moving in the direction of formalizing Hawaiian immersion through having a superintendent, and which I think is a good idea. So I would recommend supporting that bill.
Okay. So let's start with that one then, which is at the bottom. So there is a motion to support, help me again, the number, because I don't have it on a piece of paper on the side here. What is the number of that bill? 199? Well, no,
No,
14.
it's John, you're talking about HB
Yeah,
1496, right? Yeah, okay.
right. Yeah, that's the one.
All right. So the motion is for the Hawaii Civil Rights Commission to support House Bill 1496. I had eye surgery the other day, so I've had a little bit of trouble looking at my screen. Going, help me! No, so okay. So that's the motion. Is there any debate? This motion is coming from Dr. John Matsuoka.
My children went to Hawaiian immersion, and I'm pretty familiar with the program, and I just think it's kind of it's a good idea to further develop the Hawaiian immersion program, and so that it gains greater recognition within the DOE. And it also sounds like it's a move towards greater independence, and they'll have a stronger representation to whoever before the legislature or even within the DOE.
Okay, is there any further debate? Hearing no further debate, so the question is, and I think we have to take a real vote on this one. Nobody else has spoken. So those commissioners who are in support of endorsing House Bill 1496, can you raise your hand, or because we have to record this vote? And I'm not seeing any hands, but I'm assuming John's hand is up. Are there any other hands up?
Mine, Joanne Adams.
So that's 2.
Yeah, I raised my hand as well.
Oh, so actually, three of you are supporting this. So let's say this then, as your chair, so that we don't have to record everyone's vote. If there's no objection, the Hawaii Civil Rights Commission will support House Bill 1496. And I
Right.
see no objection. So let's have it that way. Then we don't have to have individual votes recorded.
Very good.
Oh, very good. All right. Are there any other on the list that a commissioner would like to make a motion or speak to, for or against? And I'm not hearing anything, so I think at this time we can safely say that all the other bills, which the commission had recommended we not take a position on, that's what it will be, because the commission itself, or the staff, has recommended no position, and no commissioner is moving to separate them out and take a position. Therefore, all of the bills, which I will not read, if you don't mind, by title, will we will not take a position on. Civil Rights Commission. So, very good. So
Thank you.
can
Thank
we
you.
move along to our next?
Right. And so again, because there were bills that dropped out, we're not going to be following strictly what's on the agenda, but these remaining bills for which staff thinks we do need some commission action are listed in order. So starting with GM 589. And so this is one we strongly support, which would be the consideration and confirmation of Joanne Adams for a term on the Hawaii Civil Rights Commission to expire June 30, 2028. And we have begun drafting some testimony. And so once a hearing is set, we will let all of you know. So position would be to strongly support.
Okay, so the position of the staff is to strongly support. Therefore, the motion before the commission is for the commission to strongly support Governor's message 589. Supporting for consideration and confirmation to the Civil Rights Commission gubernatorial nominee Joanne Adams for a term to expire on June 30th, 2028. Is there any debate?
I just have a point of information.
Yes.
Do I abstain from this since it's about me?
I don't think that is necessary
Okay,
unless we go to a individual voting. But the
okay.
question will hopefully be, there's no objection. Unless you object, Joanne.
No, I'm honored. Thank you.
Sure. Okay, we're also all honored and eager to see you join us, not as interim, but I think I can speak for the commission saying that as well as the staff. So if there's no further debate, is there any objection from any commissioner? Since there's no objection, this motion is adopted to support the governor's message 589, submitting for consideration and confirmation to the Civil Rights Commission, Joanne Adams as gubernatorial nominee.
Right.
Okay.
Next, we have
Go ahead.
Senate Bill 1061. This is relating to digital equity. So as stated, it establishes and appropriates funds for a digital navigator pilot program to offer technical assistance with computers and electronic devices to residents. So this is something that we think will help increase access to public services, and particularly with those individuals with disabilities, possibly those of an older age. And we do see that this can be a barrier to some people who would otherwise access our services, to be unable to do so. And so we would support this measure.
Okay, this is for those of you who downloaded the legislative summary. It's on the second page, and it's lettered A, or excuse me, I. KL,
Right.
sorry, L, okay. Well, my eyes will one of these days get around to actually focusing on the page. So Senate Bill 1061 relating to digital equity. And this is a companion bill to the one we've already considered, House Bill 935, right? And so I think we indicated support for that. And if that being the case, then the motion is to support Senate Bill 1061 relating to digital equity. Is there any discussion? Hearing no discussion, is there any objection to the Civil Rights Commission endorsing and supporting, I should say, Senate Bill 1061? No objection there, so the Senate Bill 1061 is supported by this Hawaii Civil Rights Commission. Thank you.
Thank you. And I'm trying to navigate a number of windows here, so hopefully the recording is okay. Next bill we are considering is Senate Bill 1149 relating to hate crimes. This is a bill that would require the reporting of possible hate crimes to the appropriate authorities. It would require law enforcement officers to receive annual training to identify, investigate, and document hate crimes and possible hate crimes. It would also require the Attorney General to establish or update guidelines, protocols, and training materials for the reporting and investigation of hate crimes and possible hate crimes. We think this is a good bill and staff would support.
All right, on the recommendation of the staff, it is moved that the Hawaii Civil Rights Commission support Senate Bill 1149 relating to hate crimes. Is there any discussion? Hearing no discussion, is there any objection to the Civil Rights Commission supporting Senate Bill 1149? Since there is no objection, the Hawaii Civil Rights Commission adopts the motion to support Senate Bill 1149 relating to hate crimes.
Okay, thank you. Next, we have Senate Bill 1493. This is an interesting one. So I'm going to go over the summary and then actually show the text of the bill. So this would require a number of different things with relation to service animals. So first of all, requires sellers or providers of emotional support animals to provide written notice to the buyers or recipients that the animal does not have the special training required to qualify as a service animal. This is as written, so I'll talk about what the current status is. Okay, the animal is also not entitled to the rights and privileges accorded by law to a service animal, and knowingly misrepresenting as a service animal any animal that does not meet the statutory requirements of a service animal is a violation of the law. Okay, so that has to do with the sellers of the animals themselves or providers of the animals themselves. Secondly, it would require sellers or providers of paraphernalia relating to emotional support animals. So certificates, identification tags, things of that nature. Require them to provide written notice to the buyers or recipients that the item does not entitle an emotional support animal to the rights and privileges accorded by law to a service animal, and also prohibits the knowingly misrepresenting the animal as a service animal. Okay, and has penalties for that. So I'm going to share the law itself. So this is the updated second version that we have, SD1. So there's some issues here, and I think one of the issues we had was there is a law in the books that already makes it unlawful someone to knowingly misrepresent a service animal as knowingly misrepresent an animal that's not a service animal as a service animal. So typically you're talking about an emotional support animal that's being represented as a service animal. So that would be unlawful already. This extends this thought to the sellers of the animals as well as the sellers of paraphernalia related to those animals. And so what we have here is here, these are the additions. In the original bill, it added this section A, so the sellers of the animal, and it added section C, a person or business that sells certificates, vests, identification tags, etc. And I think we can have discussion about whether that is something we support or not. But what I would also add is with this new version, I'm pretty sure what happened was in the testimony that I saw, DCAB, the Disability Communication and Access Board, recommended that there be additional prohibitions, and this is for a person or business who provides verification of the disability-related need for an emotional support animal has to provide written notice of the same sort. You know, that the verification cannot use to be established the emotional support animal as a service animal, not entitled to the rights and privileges, and prohibition of knowingly misrepresenting. So I think there are some issues with all of these provisions, but I have a real problem with this one regarding the entity that provides verification of the disability. And I don't think that that is appropriate to place that burden on them, and it may have a chilling effect simply to verify that the person has a need, a disability related need for the animal. And one example might be if you have someone who is suffering from PTSD, maybe a veteran, military veteran that's suffering from PTSD and really benefits from an animal, which is not a service animal, but is an emotional support animal. And that person needs some verification in order to, have the animal in housing. It doesn't have to be a medical provider. It could be, a social worker, a mental health expert. I mean, so these are people who are not even being paid for their services. They're just verifying that this person needs this animal because of a disability. And I don't think it's right to impose some sort of requirement on them that, there's penalties for. So I can answer any questions that we had. We discussed this in some detail. So and the method for, I guess, finding a violation appears to be a civil action. I mean, there's no other entity, agency that's specified that would, handle complaints or alleged violations here. So anyway, that would be, I think, the staff's analysis of the bill. And we did not really come to a recommendation as to position. And I think we leave it to the commissioners to, propose whatever they feel is appropriate.
Okay, since there's no recommendation from the staff, then is there any commissioner who wishes to move to either support or oppose?
I have a
Joanne?
question. I have a question first. When I read this, it struck me that they were trying to address the issue of fraud. So is there fraud going on about identifying people who need emotional support? Was that mentioned at all in any of the reports or testimony that you're aware of?
Yes, I mean, I think that is one factor. I think putting it in a more positive light, there maybe is a lack of information and understanding about what constitutes a service animal opposed to an emotional support animal. But there also are people who feel that there are intentional misrepresentations, and I don't doubt that that's the case, right? But as far as the scope of the problem, I couldn't say. But there are factions that believe that this is a real issue with abuse, and also just outright lying and taking advantage of the system. And so this already there's a law in the books that says that for a person with the animal to misrepresent that the animal is a service animal, that's a violation. But this goes a step further to say that those who are selling and providing the animals, as well as those providing tags, vests, etc., have an affirmative obligation to provide, like not only verification that, or they have to provide let me see what it says here. Written notice to the buyer or recipient that the animal does not have the special training required to qualify as a service animal. The user of an emotional support animal is not entitled to the rights and privileges accorded by law to a service animal, as well as knowingly representing would be a violation. So that's what is going to be, if the bill passes, imposed upon the sellers here.
What is all that?
So if, while we're waiting for anybody else to jump in, I recall getting training on this when our offices used to be in the library at West Oahu. And so we were told, don't ask, don't tell on this one. If somebody comes in with a dog, unless they're causing a problem, let it alone. And so we didn't try to distinguish between a service animal or an emotional support animal. I don't know how, but you say there's already something on the books that it's for service animals only, but not for emotional support animals. So anyway, I think that distinction is really, really important. What are they being purported to be? But I don't know that I support all of the details that are in all of this. So I myself don't see pressing this forward. But are any of the other commissioners? Up to you. I mean, any commissioner can move either to support or to oppose. Or we could leave it alone.
I can only report what I've observed in watching this whole thing from, and I will admit that my view is biased because I live in a condominium with house rules. And it seemed to me that I saw a lot of personal fraud. People that I knew who had small dogs who said I can take him anywhere because it's my emotional support animal. And I'm kind of going, oh, really? And so the cavalierness of it bothered me. And that's why when I saw that this was dealing with fraud, I thought, well, that kind of comports with what I saw. I think there's also been a lot of pushback because service animals are highly trained, and they're usually with people that are disabled and fall into one of the other categories. Emotional support is clearly a lot softer. And then you have, in response to that, grocery stores and restaurants, in other words, establishments that have food, and they're trying to react to whether or not you should bring animals in there, because historically you do not allow animals where there is food or the preparation of food. So it seems to me that it really is a cultural tension here. And I kind of am, I'm not sure about this particular bill, but it does seem to me that it needs some formalization and clarification, because I have a friend that throws a service animal vest on their pet dog and takes it around as if it was a service animal, and it is not. It is a comfort animal. There's no doubt it gives comfort, but it's not the trained service animal. So I am, to the extent that they're trying to control fraud, I support it, I guess is what I'm trying to say in a very lengthy way.
So would you move to support this bill?
Oh, is it appropriate for me to make a little comment?
Well, of course.
So Hawaii's revised statute 347-2.5, it defines a service animal, and in that section, It says other species of animals, whether wild or domestic, trained or untrained, are not service animals for the purpose of this definition. The work or tasks performed by a service animal must relate directly to the individual's disability. Neither the potential crime deterrent effects of an animal's presence nor the provision of emotional support, comfort, or companionship by an animal constitutes work or task for the purposes of this definition. And I mean, I bring that up because, um, neither the potential crime deterrent effects of an animal's presence nor the provision of emotional support, comfort, or companionship by an animal constitute work or task for the purposes of this definition. Just because it's on the books about support animals. And yeah, it is a cultural divide. So I just wanted to put out that there is law in the books about this.
So in that law, is there any penalty for misrepresentation?
There is no. It's just a
Oh.
definition.
But the definition makes it very clear that service animals are not comfort animals.
Right, and there
And they are
is a
distinguishing
separate
between the
law.
two.
There is a separate law that does prohibit, and I'm sorry, I can't recite it off the top of my head, but there's a separate law that prohibits misrepresenting a non-service animal as a service animal.
Oh.
Right, so that's established law. What I would say, I think, to provide some context is that where service animals really have a difference in treatment as opposed to a non-service animal that's an assistance animal. So let's, for the sake of just ease, we'll call them emotional support animals, but there are other types of animals that would qualify as assistance animals. But let's say emotional support animals versus service animals. So it's really in places of public accommodation where the treatment is different. So if you go to Costco, I mean, yeah, there's signs saying you can't bring in animals except for service animals. And that's a correct interpretation of the law. But there are real legitimate needs for assistance animals that are not service animals in other contexts. And it could be in employment, particularly in housing, right? I mean, there are many people who need an emotional support animal because they have severe depression, they need a reason to get out of bed, or PTSD. So there are really legitimate reasons why these animals are necessary. So if I had to throw in my 2 cents here, I think fraud is a legitimate reason to consider some of these measures here. The real issue I have is with the section B, which is about providing verification of a disability-related need. I don't think that belongs here. I think it is, it exceeds what the original intent of the bill was. And I don't think we should, potentially penalize people who are trying to assist people that need assistance animals in verifying their need. So that's my 2 cents.
And if I could support Marcus, I just did a training in the judiciary about recognizing accessibility for individuals with invisible disabilities. And according to the CDC report, 94% of people with disabilities in the United States do not have visual aids, such as a wheelchair, canes, hearing aids. In this case, maybe a service animal for a person who may not be able to see. And so it is a gray area, but the section here providing verification, I think it does have a chilling effect as well. It's like a balance, right? Like people who have individual disabilities, mental health conditions, neurological conditions, may feel the stigma. And on my training, I said stigma is a challenge that's faced by individuals with disability because of the accusation that they're faking it. And while there are situations that have been brought up in this conversation, it's already difficult accessing accommodations in like a public accommodation space, like say the judiciary, where there's a very high stress type of environment where a legal decision is being decided by a court of law for people who already are facing negative assumptions about their um you know their abilities. So I fear that this language shows that, and also see it in my cases. I don't want to talk about them, but yeah.
To me, again, I read section B very differently. What I feel section B is saying is the person who provides the animal for an emotional support has to make it clear this is not a service animal. And I think that's appropriate. Service animals are very, very different. They're much more
I think
highly
what they're,
trained. They're much more owner specific. Those who have service animals will often tell you, don't get near my dog, because they're usually dogs, because the service animal is so trained to be single owner, they could actually reach out negatively to someone who is not the owner. They're very, very different, I think, from an emotional support animal. And
yeah,
I wouldn't be surprised if this particular thing isn't coming from the service animal industry that to me seems to be fighting for its very life, that there's a huge difference between service animals and this newly defined emotional support animal.
Okay, so,
Joanne, I don't think their staff's disagreeing with you about the
Okay.
distinction. Section B specifically relates to people who provide verification of the disability. So they verify who can have an emotional support animal. I think that's what staff is having an issue with.
thank you. So could I ask again, because now apparently it's not just my eyes that are bad, it's my ears. So the problem that Marcus, you were talking about, is it B or D, like dog?
B as
B,
in
like
boy.
boy.
right.
Yeah.
Okay, just want to be sure.
Verification of the disability. So someone who gets to say you can have an emotional support.
Right.
That's the problem that
But they must, but it says it
staff.
must provide written notice that it cannot be used to establish that this animal is a service animal.
The verification
Yeah.
cannot be used to establish, so proof of someone's disability. That's
Yeah.
the problem.
And that the
And
emotional
I think,
animal is not for purposes of rights and privileges. It's not a service animal, because there are so many more rights and privileges
right,
of
but
access if it's a service animal.
right, but wouldn't your concerns be addressed with A and C? Like, I think that your concern that making a distinction between emotional support animal and service animal, that I think that falls within A and C, but who gets to decide someone has a disability? That's the concern that's being raised by staff, and I happen to agree with what they're saying.
Okay. All
So-
right. I see how when you reframe it, it does take on, you're focusing on the actual individual in B that has
yeah.
to make the
Yeah,
verification.
verification of the
Now
disability.
I more clearly understand.
Yeah,
That
that's
that
it.
person should not have the onus of
Yes.
subsets 1 through
Right.
3.
Yeah.
Okay, thank you. You've
Oh.
convinced me.
So, well, I'm not sure which direction. One of the things we have done in the past is we have said we support a bill with the following reservation or with the following,
with
so,
comments.
yes, in the comment.
Yeah.
So one possibility would be for us to adopt a support for this, but with, reservations or about section B.
Yes, that would be my motion.
Okay,
I will
Very-
second that motion if you need a
Yes.
second.
I think I just said we're all in agreement would be the good
Okay.
thing here, so I wasn't sure. So I like that to then be the motion that we will be considering for adoption unless there's any further debate. And hearing no further debate, then is there any objection to adopting the motion to support this legislation Senate Bill 1493 with reservations concerning section B, which we do not support. How's that for wording? I'm not sure. Anyway,
Oops.
if that's acceptable to everyone, in which then I will say, if there's no objection, that's what will be adopted. Hearing no objection, so let it be written. So let it be done.
All right, thank
Okay.
you. Moving on. Senate Bill 1660 relating to employment. This is an interesting one. Okay. So again, I'm going to read the summary and then go to the actual text of the bill. This bill would require employers in the hospitality industry specifically to implement anti-harassment measures, provide training, and equip certain workers with panic buttons. Okay, and it would prohibit retaliation against a hospitality worker who either files a complaint, uses the panic button, or participates in an investigation or proceeding relating to a harassment complaint. It would require the Department of Labor and Industrial Relations to adopt rules, including rules determining penalties and establishing procedures for handling complaints. That's a summary. So I'm gonna shoot over the bill itself. Okay, let me consult my notes here. So this is interesting. We recognize that harassment is an issue in the workforce, and we do recognize, especially in the hospitality industry, it's been a major issue just in the news and cases we've seen. And so, we support measures generally in any industry that would help to protect employees. Okay, so let's go here. Oopsie. No.
Hey, Marcus, I'm not seeing
Yeah.
your screen if you're
you're
trying to
not?
share. Maybe you're on the other monitor. Yeah.
What
I
are you
wasn't
seeing?
sure if you were navigating your own windows or
Yeah, what are you seeing now?
I'm seeing you.
The
Oh,
bill. When I can see you and the bill.
I can.
you can see
Oh, you
both?
can?
I
Oh, okay.
can
Maybe I'm
too.
on the wrong view. I'm sorry. Forgive
Okay.
me. Okay, I
Okay.
found it now. Sorry.
Okay. So, yes, so harassment would be unwelcome conduct based on protected characteristics, including race, sex, national origin, or sexual orientation that creates a hostile, intimidating, or offensive working environment. So essentially, this is harassment as we understand it and is within our jurisdiction. So we have, any hospitality industry would be an employer, and as long as there's one or more employees that would fall within our jurisdiction. And as stated, this is a type of matter, harassment that would fall within our jurisdiction. So what this bill calls for is for the Department of Labor and Industrial Relations to create a whole system of complaint filing and reporting. And so, we don't think that that is needed or wise. So here it says that under 4C, or under C actually, a hospitality worker who is subjected, oh, I'm sorry, no, let's go to 4 complaints. Um, I'm sorry, I'm not really honing in on where the language is, but I can tell you that it's directing the Department of Labor and Industrial Relations to create this system, and they would be responsible for taking complaints and reporting them. Wait, I'm getting
So
this
that
wrong.
one,
I'm
4
sorry.
and 5, right? You're looking at, there's the procedure, how you file a complaint and then penalties. Is that what you're thinking of?
Yeah, no, I'm sort of mixing up facts here. Let's see. Let's get this correct. Okay. So what it says, first of all, employers have to have a written policy prohibiting harassment of hospitality workers. Okay. Number 2, provide mandatory annual training for hospitality workers. Number 3, supply a panic button to each hospitality worker who works in guest rooms, restrooms, or other isolated conditions. Okay. And provide hospitality workers with a list of resources, including contact information for the LIR, Equal Employment Opportunity Commission, local advocacy groups specializing in harassment prevention and victim support, as well as statewide sexual assault survivor service providers and hotlines. Okay. So those are what's imposed upon employers. And display a notice of these rights and protections. It also prohibits retaliation. Okay. Oh, here we go. Okay. It says here, the Department of Labor and Industrial Relations shall establish procedures for receiving and investigating complaints of retaliation or other violations of the chapter, develop and distribute guidance for hospitality employees, conduct random and targeted audits of hospitality employers to ensure compliance, publish on the department's website an annual report on the department's enforcement activities under this chapter, including the number of and types of complaints received, resolutions achieved, and penalties imposed. Okay, so we've had some discussion about this, and I think the idea is a good one. I don't think it makes sense for this bill to mandate that the Department of Labor and Industrial Relations create new procedures when this is the type of matter that we have a whole system for, and we regularly take in complaints of this nature. So if like exactly these types of claims that are contemplated are already filed with our office, right? So I guess I'm unclear, and as staff, we're unclear how to present our position on this. But there's a couple things. So not only would the Department of Labor and Industrial Relations take in these complaints, but they'd also impose additional fines on employers, like per violation. And that could include, monetary fines, reinstatement of hospitality workers, payment of back wages, or even to revoke or suspend the hospitality employer's business license. Okay, so it's kind of a a major thing that's being presented here. And again, I think we as staff recognize that the intent is good, but the details here, need some working out. So that would be our analysis of the bill. And hopefully we have some commission discussion about that.
So here again, we have in the past said we support a bill or the intent of the bill with the following concerns. And then we could ask the staff to articulate some of those concerns if you're ready to tell us about them now.
Well, yeah, I mean, our concerns would be that there already exists a working system to take in the types of complaints that are contemplated here. So we feel there's no need to create a new separate competing system of complaint filing and investigation. I think, I mean, that to me is the main part, is, not having a duplicate system for filing harassment complaints.
Can you move back up a little bit? What is
Sure.
that, section 2 essentially? Section 2 is it all of section 2 that you could indicate your concern for, or we could indicate concern for? 3.
Well,
Wait a minute.
yeah, I think, well, see, the part about, and I saw, we do
Just
have a hand up
prohibition
here.
of retaliation. Yeah,
Yeah.
3.
Okay, so it says Department of Labor and Industrial Relations shall establish procedures for receiving and investigating complaints of retaliation or other violations of this chapter. So to me, that is broad, but it does read that the DLIR would establish the procedures and they would receive and investigate the complaints. And again, these are harassment complaints. These are things that are already covered by the laws that we enforce, and we regularly take in these types of complaints as well. So that would be the concern, is not creating a whole separate
Sure.
thing that would
see.
somehow compete with what we already do here. Now, I don't have much concern or problem with imposing certain obligations on employers, such as having additional training, having the panic button. I mean, that's not something I ever thought of, but I think it's, it's a pretty good idea. So those obligations, I don't think, at least I would have an issue with.
So we have a hand up from our member of the public here, Mr. Galoyu.
Good afternoon. Yes, Michael Gloria Jr., President of Pride at Work Hawaii, he, him pronouns. Pride at Work caught this bill by accident at the legislature. We were there for another bill, and we were sort of disappointed in the director's testimony when he said he opposed it, but that you all would be meeting. And that's one of the reasons I'm here today, is that to advocate on behalf of this bill. Is it perfect? No. Are there things that you need to amend in order to use your system? Yes. But the employees need to know that they can actually come to you when they're being harassed by customers, that they are frontline. The tourist industry is our second largest employer after the federal government, and we need to support them. And a lot of them feel, especially those that do not have a union behind them, do not have that support. And so it'd be nice to know that they actually had the state government there to support them. And this idea that the customer's always right is not true, and that they do not have to deal with discrimination and harassment from a customer. So whatever problems there are within the bill, I hope you can figure out a way to fix that, or at least suggest amendments to them when this bill goes up for a second hearing. Mahalo.
Thank you. So we don't have yet an articulated recommendation from the staff, right? But I think that leaves us with either opposing it, taking no position, or supporting it with reservations. So
Well,
I'm inclined
I see
toward-
Commissioner
Yeah.
Adams has her hand up, but
Yeah.
in terms of staff
Yeah, may I ask
recommendation,
a
I could
question of
speak
the
further.
staff? Is there anything in the bill regarding the department where they're asking you to do things that you would not want to do? Or is it just a presumption that they're asking you to do a whole system that's already there? In other words, would a phrase like that are not currently provided by the department kind of clean it all up in a short little phrase?
I'm not sure that would be an absolute cure to what our concerns are. And I think if I'm hearing that the issue is that hospitality workers need more information and easier access to be able to file complaints with discrimination, I mean, that's something we can certainly get behind. And so, I mean, if it's a matter of some kind of like I mean, I like what's here. It's a written policy of harassment, mandatory annual training, providing a list of resources. And so maybe the list of resources could include the Civil Rights Commission specifically, and have some mention about the types of claims that can be filed with the Civil Rights Commission as well as the Equal Employment Opportunity Commission. So that is great. I mean, I have no issue with that. I think the way that the bill reads, it does indicate that there would be new procedures created and new penalties, et cetera. And I can't speak to, what the department's position would be on this last part about penalties towards the hospitality employers. But that's not something that I think would be within the jurisdiction of the Civil Rights Commission. I mean, we would adjudicate claims, specifically those claims within our jurisdiction. So, I mean, violations of this particular section, I think, would not fall within our purview. So, hopefully that provides some
Okay.
clarification on our comments here.
So I think, if I'm reading the rest of the commissioners correctly, we want to support this bill with certain reservations that, you could maybe speak to, or so that we'll know what you're planning on saying with the reservations, such as Section 5 penalties or something. If
I'm,
that's
I'm wondering about these panic buttons. Does everybody get a panic button? And are hospitality workers at much greater risk than, let's say, any other sector in terms of harassment? And that kind of gets back to Marcus's comment about already, there's already kind of protections in place. So those are the questions that I have.
Okay, well, those are obviously legitimate questions, and if Marcus would care to address them right now, but I'd like to think that we at least have a motion pending, which is to support the bill with reservations. And then the reservations could be.
Chair, I
Yes.
just did a quick search because the bill mentioned the state of Washington.
Yeah,
And there's a Q&A, Washington State Department of Labor and Industries, about panic buttons. And it says, would a team of 2 housekeepers working in hotel rooms next to or across the hallway from each other require personal panic buttons? Yes, these employees are considered alone and requires a panic button for each employee covered. So there's that, for example.
thank you. I think that helps address the question that John had. So, is there any debate on the question, which is that the HCRC support Senate Bill 1660 with reservations? And then the reservations could be articulated by the staff.
Like that.
Is that acceptable? I'm not hearing anything. So,
Yes.
I agree. I
mean,
like
yeah.
that.
Yeah, I mean, I think the reservations as articulated by Marcus, like the fact that there might be um, uh, inconsistencies between whatever DLIR does and what we do, those are valid issues. So I agree with, while the intent is okay, we need to sort out some issues. So a reservation to me sounds good.
okay. So we could further say with reservations to be articulated by the staff, HCRC staff. Is that okay?
Yes.
Yes.
All right. So now let's go then to, if there are no objections, that is the motion that HCRC support Senate Bill 1660 with reservations to be articulated by the staff, HCRC staff. And if there is any objection to that, we'll open. If there are no objections, that is the motion that will be adopted by HCRC. Okay. Can we
Okay.
move on?
Thank you. Yes. Yes. And just FYI, so we hit some of the items that I think are going to be we'll have the most debate on. So hopefully we can get through all of these bills here. The next one I have is House Bill 22. This is relating to collaboration with the federal government. So this is an immigration related bill. And what it is that it would allow our state and county law enforcement agencies to collaborate with the federal government for immigration purposes only in certain limited specific circumstances.
Mhm.
So this is intended to limit the participation of our state and county law enforcement agencies in federal efforts to, enforce immigration policies.
Sure. It sounds like it's letting us work with the federal government as opposed to spitting in their eye and telling them to go run away. Just, but I guess can't word it like that. So, what is your staff recommendation?
Oh, yes. Our recommendation would be to support.
And-
And I would say that in looking at the testimonies provided, it does have broad support from our local legal and law enforcement agencies.
Okay, so the motion is to support House Bill 22. Is there any debate?
What are those special circumstances in terms of local law enforcement collaborating with ICE or federal?
Yeah, let me share. Let's see. Okay, so each of these has exceptions. So there's the prohibition against honoring detainer requests. And so the exception to that would be if the individual has been convicted of a felony within 5 years prior to the date of the request, or if there's probable cause to believe that the individual has or engaged in terrorist activity. Okay, so that would be for honoring detainer requests. And then the prohibition against requests for information. So this is where ICE or Customs or Border Protection are asking for non-public information about individuals. So here would be the exceptions to not complying with that. It would be the information request is accompanied by a judicial warrant. The individual has been convicted of a felony within 5 years prior to the date of the request. The individual has been arrested for a felony and the judge has made a finding of probable cause, or the individual has been convicted as a repeat offender of any misdemeanor within 3 years. Okay, so those would be the exceptions, if that was clear.
Okay, and you said that law enforcement endorses this bill. What about local immigration rights groups, and organizations?
Yes, absolutely. They support this bill. Yes.
I can answer, the legal clinic did write a comment. I'm looking up at the testimony, page 7, of the legal clinic, which did pose worry about overreach and racial profiling, and they request some amendments to the language, as well as probable cause being a reason for detaining someone. But they have other amendments on there, but essentially in support of HB 2022.
Well, the motion then is to support House Bill 22. So is there any debate or further debate? Hearing no further debate, is there any objection to the motion that Hawaii Civil Rights Commission support House Bill 22? Since there is no objection, the motion is adopted that Hawaii Civil Rights Commission supports House Bill 22.
Okay, thank you. We have House Bill 457 relating to civil rights protection. So this is another immigration related bill. It would require state and local law enforcement agencies to notify an individual of their rights when that individual is in law enforcement agency custody before any interview with ICE uncertain matters regarding immigration violations takes place. So this would be requiring that these people who are in custody be notified about their rights before, ICE comes in and does their interview. And this is something similarly that we thought HCRC would support, and it did receive support from law enforcement and immigration related groups.
Okay, so the motion as recommended by the staff is to support House Bill 457. Is there any debate? Hearing no debate, is there any objection to the motion to support House Bill 457? Hearing no objection, the motion is adopted that the Hawaii Civil Rights Commission will supports House Bill 457.
Okay, thank you. Next, we have House Bill 468. So this relates directly to the Civil Rights Commission. This bill would require the HCRC to receive and investigate complaints related to acts of discrimination committed by transportation network company drivers. Okay, so essentially Uber, Lyft, so these companies that have their drivers go out, and it's against riders with service animals. So basically, not allowing passengers or riders with service animals to ride in their cars, and also to report the results of its investigation to the Department of Transportation, which shall issue penalties to transportation network companies. Okay, so this is an interesting one, and let me share the text here. Oh man. Okay, so this is HD1. There's a lot of definitions here, so we had to sort of go back and forth amongst the different sections of HRS, but we figured out that yes, this is targeting particularly those, Uber, Lyft, those types of companies that have their have drivers like that. And then there was a lot of testimony from individuals who had experienced this type of discriminatory conduct where, because they had service animals, were not allowed into the cars. And so the bill here is again requiring the Civil Rights Commission to receive and investigate complaints related to acts of discrimination committed by transportation network company drivers and report its findings to the Department of Transportation, which shall issue penalties to transportation network companies. Okay, so I think this is our analysis is similar to that of the bill regarding the hospitality industry. And we don't have a problem with taking in these kinds of complaints, but they already fall within our jurisdiction. So this would be discrimination in places of public accommodation on the basis of disability. So we do take in complaints. We have adjudicated complaints, dealing with this type of issue. So, we don't have an issue with taking in these types of complaints, but we don't believe they should be treated differently in the way that this bill contemplates, because it says, so taking complaints in accordance with the procedures established under Chapter 368. So that's our regular, statute that covers all our jurisdictional bases. And so let's see. So not only take in the complaints, but then here, when the Civil Rights Commission has found that a transportation network company driver has violated this section, HCRC shall report the results of its investigation to the Department of Labor and Industrial Relations, Department of Transportation, which shall issue penalties to the transportation network company. So that's where we have an issue, because our present statute, I mean, it's very well established that under Hawaii Revised Statutes 368-4, that any information relating to a complaint cannot be disclosed to anyone except under very specific circumstances, such as a court order. And this extends from when a complaint is filed all the way until a complaint is docketed for hearing. So only after a complaint is docketed for hearing does it become public information that could be disclosed to people. So we have an issue here. So if the bill is asking us to provide information about complaints while like prior to docketing for hearing, then that's something that the law would not allow. I would be okay with reporting to Department of Transportation any adjudicated complaints, because that becomes public once it's docketed and becomes adjudicated, so it goes through a hearing process. I also think that that's actually fairer because there's due process, and really each side has the opportunity to present its best evidence and come up with a sort of a proper determination. So I think the recommendation would be to support the bill, but specify that only adjudicated violations would be reported to the Department of Transportation. And they also included in their most current version this subsection B stating the Civil Rights Commission shall complete their investigation and respond to the complaint within blank days after receiving a complaint. I would recommend that that be opposed because Chapter 368 already gives the guidelines for, timeframes for investigation, and that's well established. And I don't think we need to add on some, different competing deadline in there. So that would be staff recommendation.
Okay, well, so that's the motion then before us is to support House Bill 468. And is this that language only in House Draft 1?
Yeah, that B language right here is only in House Draft 1.
Okay, so so can we say then we support House Bill 468, House Draft 1, except and then indicate that we oppose this 279JB? Is that what we're looking at? And
Yes.
okay, and that 279JA reporting be only of adjudicated cases. So
Correct.
if there's no objection, let that be the motion. And is there any debate?
Yeah, so Marcus, at the beginning you said that I thought you said you had an issue with the fact that this kind of stands out, these types of acts when it's already covered. So is that not a concern?
Well, I think maybe more specifically, I don't think this bill or the introducers of this bill are really aware of what we do, like what our procedures are. And so I think as long as we make clear what our procedures are and where they're covered and that we will comply with those procedures, that's fine. The only additional part that's added on is what the Department of Transportation is being directed to do. And I don't really have an opinion on that other than, I mean, there might be some opposition to that as being a double penalty or something of that nature, because we would go forward with whatever case we have. And if there's liability and remedies, I mean, we go through with that. So if the ledge thinks that this is a good idea to have this additional, I don't know, hammer or penalty, then I guess that's for them to decide, or Department of Transportation to weigh in on that,
Well, my question is, do we even, and William, this is probably for you, do we even need to say support? Why can't we just do comments? Or like, do you need an actual, because it's already provided for, so then can't we just say, I mean.
How about supports the intent of the bill? You know, because with the following comments.
Yeah. I'm not sure that, yeah,
Because either that or just
it's,
take
yeah,
the.
I'm just not sure procedurally how that looks. I mean, it's, if we're saying it's already covered, why do we need it? Is that kind of a support,
Well,
a weak support? I don't know. I don't know what it's called.
yeah, well, again, it's kind of problematical to have comments on a bill that we don't want to take a position on.
Well, that was my question to you.
Yeah, I don't think
Do we
that's
need a position? And you're
doable.
saying, yes, we do?
Yeah, at least to
Okay.
say that the weakest thing we've ever done or ever do is to say we support the intent of the bill with the following concerns.
Okay.
And then
Okay, if that's the weakest part of weakest we can go, I would actually be more in favor of that because I don't like when there's duplicative acts like this. As an attorney, it makes it very difficult to do our work. And it's sometimes inconsistent.
well, you could, we didn't take this motion we could vote this motion down and say we oppose this House bill,
Well, it's already covered, so we're not, I mean, we do protect against discrimination
Yeah, but that,
on this basis.
we could say that we oppose it. In other words, first deal with, we're not going to, support it, and then vote that down. And then take up another motion to oppose this bill for the following reasons. And then you could articulate that, the protection is already afforded under existing statute.
I just want to say I have a hard stop at 3 o'clock.
Yes, I do too. Oh, wait, it's 2:58. Yeah, I do too. Sorry.
Okay. Well, can we finish this one and then we'll hard stop?
Yeah.
Could we have the staff create some phrase, because this is twice it's come up with now, that says basically with amendments to comport to existing procedures or something like that?
Well, then, being that we are at a hard stop, it's going to be difficult to do any, writing at this stage, and I wouldn't put that burden on them to try to come up with something right now. We can hold this until, because we're not done, so there'll be another meeting. All right,
Okay.
so we can start here. In the meantime, it would be good if staff maybe had a thought about this. But I have no problem either way, saying we support it with reservations and then list a whole bunch of reservations, or we oppose it. Primarily, the reservation would be that there is existing statute and blah, blah, blah. So, and then list all the other problems you have with it about the reporting. So let's stop here, and we should pick a date, I guess, for an adjournment. Can we do an adjournment rather than a whole new meeting? Then we just pick up with where we were on the agenda. So, do you have a date? Because if the adjournments, I don't think. Well, I'm Sunshine Law. They're crazy. So, under ordinary Robert's rules, you don't have notice requirements with adjournments. If they're spelled out in your bylaws, that you don't have to comply with them because it's an adjournment. But I'm not sure about the sunshine statute on that, so maybe we need advice.
Oh, yeah. Yeah, I don't know about that either. Adjournment. Wow.
Because it's a continuation,
Right.
So, and it's we don't have to have minutes, so a bunch of different things. We can pick up where we left off to finish this. And I'm thinking that would be a smarter way to go if it's okay under the sunshine law. But in the meantime, can somebody suggest to me a date? So let's just say we could do this next week on the 20th.
Works for me.
At 1 or at 2?
I think we could. What do you think in terms of what's left, Marcus? Would 2 o'clock do it?
Well, let's
Unless
see.
people want to leave at 3, in which case we probably have to start at 1.
Okay, so we have that bill. If we count that bill, we have 1, 2, 3, 4, 5, 6, 6 bills.
I would prefer earlier because, yeah, I have a filing that day, so.
Okay, let's say 1 o'clock on the 20th.
Okay,
And that's our plan unless there's some problem that you folks encounter with the OIP.
I think that should give
Yeah,
us enough
because
time regardless.
that's
yeah.
6 days, so I need
Hey.
6 days in order to post on the lieutenant governor's site.
Yeah.
So
But the difference, the key thing is in
the
an adjournment
continuation.
is you don't have to make a brand new agenda.
Mm,
Yeah.
Yeah,
You
so I
stay
can
with
just do
with
it continued.
Yeah, continued. That's
Mhm.
right.
okay.
So let's try that on the 20th at 1.
1
Okay,
o'clock.
Sounds
Right.
good.
thank
Okay.
you.
good.
Thank you all.
Thank
Appreciate
you.
Thank you.
due diligence, and we'll see you in a week.
Yeah, I'm gonna stop.
Aloha.
Thank
Thanks,
you.
everyone.